This is Liberty Law Talk, part of Liberty Fund's online library of law and liberty. Your host is Liberty Fund Fellow Richard Reinsch. Our web address is libertylawsite.org, where you can subscribe, comment, find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org. Today we are discussing with John Inazu his latest book, Confident Pluralism, Surviving and Thriving Through Deep Difference. John Inazu is the Sally Danforth Distinguished Professor of Law and Religion at Washington University Law School in St. Louis. He is the author of Liberty's Refuge, The Forgotten Freedom of Assembly. John, welcome to the program. Welcome back, I should say. Your book, Liberty's Refuge, was one of the first podcasts we did, so it's glad to have you back and continue this discussion on freedom of religion, freedom of association, and now as you're addressing it solely through the lens of a pluralism and pluralism, making this book timely in light of just so many instances and events that have happened, almost too numerous to mention. That's sort of suggesting we're a country no longer one that can handle difference, no longer one that can handle people of comprehensive worldviews trying to exist and tolerate one another, but really actively using government and power structures to in certain cases force people out of the public square.
Richard, it's great to be back on the podcast, and you're right, mentioning even the events of the last few months that have transpired since the book came out. It's pretty stunning to think about the number of examples we can draw from to highlight this difference and disagreements.
So, why did you write this book, Confident Pluralism? And when you sat down to write it, what was in your mind and what was motivating you?
Initially, it grew out of my work on Liberty's Refuge, where I focused on the historical and theoretical contours of the First Amendment's right of assembly, and out of the assembly framework, I started focusing on these ideas of difference and dissent and faction and the kinds of constitutional rights we have around protecting that kind of difference and dissent. And as I thought more and more about it, I was realizing there's not only a political theory, but also a cultural connection here to how we navigate these kinds of differences in our society. And so I knew I wanted to write something focusing on the constitutional health or perhaps illness of some of these doctrines. But then I also realized as I got more into the project that there's a civic dimension to this entire thing. In other words, while we need strong constitutional rights, we also need a kind of citizenry that understands the importance of living among difference, and we're lacking in that as much as we are in the rights right now. So
what do you think is, you've got, first part of your book is about constitutional rights, constitutional liberties, and sort of a constitutional consensus. It's a small case C constitutional consensus. And then you just mentioned the second book, which I kind of put under the rubric civic virtues.
Right.
In my mind, that's what you're discussing. But of course, to get civic virtues right, we've got to know what the political order is about to begin with.
That's right, and so maybe two small qualifiers there. One, I avoid the term virtues in the book. I started off. I know. It's a frightening term. Well, it's a frightening term only because virtues require practices and institutions to sustain them, and I worry about whether we have those today. And so I punted and I used the word aspirations, but eventually aspirations have to turn into virtues if we're going to, or some kind of habits or practices. And so the terminology that you're pointing to is really important because it does matter in the long run. I'm just not sure in the short term if we're going to be able to get there. And then the other part I'd mention is you mentioned the constitutional consensus in the first part of the book. I call it a modest unity, and maybe an emphasis on the modest part, that I think as a constitutional matter where our agreement lies is a relatively modest kind of agreement. We have to have something, though, and the alternative of kind of a chaotic anarchy is not attractive to anyone.
So I want to disagree with you in part, agree with you in part on the first part of the book. When you say modest unity, you start with the Bill of Rights, and I think that's probably that's true so far as it goes, the rights and liberties they're enlisted as being a part of what most of us think of as, what constitutes being an American now. My concern, though, and where I disagree with you is, if this is the foundation of our constitutional consensus, I wonder if the way it's been defined, both by the court, but also in more popular understandings, is that it has resulted in, the memorable phrase from Professor Glendon at Harvard Law School, rights talk. That is to say, long on rights, short on duties, or really non-existent duties and obligations. And so we have this maximum circumference of rights. We can do pretty much what we want in some sort of million framework, as long as we don't hurt other people, whatever that means. And that's sort of the essence of being an American. But, in even more deeply, I wonder if also, even in that sort of rights framework, we've forgotten what's most fundamental, I think, about our Constitution, which isn't the Bill of Rights. It's actually deliberation and separation of powers and representation in the Congress, and that sort of mediation process, that give and take, log rolling, compromise, bargaining, which allows these deep differences that you discuss very well in the book to all get some sort of representation and some sort of outcome, and that actually is missing. In part, I think it begins with the court, and the court can't do that. The court just gives you a very exclusive rendering of a right, and there's a winner and there's a loser.
Yeah, I like everything you just said, and I think it's all part of the puzzle. But I think maybe the reason I focused on the Bill of Rights and these First Amendment provisions is they tap most naturally into a kind of pluralism ethos or narrative that I can draw from. And so when we think of the great text from cases like West Virginia against Barnett and the great lines of constitutional decisions that are written for the broader public as much as they are for other judges and justices, there's a kind of narrative that I can draw from there. But I think you're absolutely right to talk about the other structural provisions of our Constitution as necessary and important, especially in the long run. So the separation of powers point, which is on everyone's mind right now, and the stakes of this presidential election being so much starker because of, particularly in the last 20 years, recent changes to executive authority and the constitutional necessity of trying to right that imbalance. Another issue here is the question of federalism, and in some ways, I think that the argument I start to outline in this book maybe counsels toward a kind of federalism in all of this, which then is complicated by just questions of size and geographic dispersion. And so when we think about the framers and the footprint they had in this country and the number of people in this country and how different we are today, both in terms of scale and size of the country, and how much pressure that puts on all these questions. So I think they're in the background. You're right to point to these other constitutional questions. I think I was trying to create a simpler narrative for a more public audience.
Yeah, no, as I read that, and then it kind of brings to mind too the rights talk, as that's also been influenced within the academy and as you know, within the legal academy and the federal judiciary of a Rawlsian framework where rights, there's little, once something is deemed a right, what could be compromised after that? It's a monopoly, it's all consuming, it's a trump card. And within that framework, those who disagree, and in many respects you've got now, anywhere from 40 to 45% of the country that disagreed with Obergefell, yet 5 members of the court very confidently told them they were bigots. And so this is, I think, this sort of dynamic where you see control of an institution like the judiciary or the administrative state, and then the ability to use that and not, in a way in which you overrule fellow citizens, and then kind of, state you really have no rational standing to begin with. I mean, it seems to me that's driving what's at issue in your book.
I think in some ways, I think the rights question is really complicated, and I think there is a danger that you describe in terms of the conversation stopper dimension of a rights claim. On the other hand, particularly with the actual rights we have in the First Amendment, maybe the problem today is less Glendon's problem about too much rights talk and more in the current era, too little rights talk. And so I worry about, for example, 26 years after employment division against Smith, what is left of the right of free exercise of religion, or on college campuses today, what really is the free speech right? And so in some ways, while I recognize and understand Glendon's point about rights talk, particularly the missing aspect of responsibilities, I also think that with respect to First Amendment rights in particular, this might be a moment for more rather than less rights talk.
Yeah, no, that's all well taken. I mean, and I think you talk about this in the book with regard to employment division versus Smith, the way in which a response to that has been to kind of put religious freedom into other rights in the First Amendment and to try and vindicate through freedom of speech, what's being disputed, and so I guess in one respect that's a way that we've tried to deal with. I guess my concern would be, if we think about that employment division versus Smith, the other part of that is that might not be such a bad outcome, the holding decision, but for an incredibly massive government. And if you have an incredibly massive government that affects numerous ways in which people are living, then you do need to have some sort of exemptions or a healthy understanding of why you would want those in that context.
Yeah, I mean the growth of the regulatory state and the increase in the number of clashes and disagreements that arise from regulation, and also the growing number of religious institutions, right? We create just amplify the number of situations where we might have a litigation arising. So we think about churches as institutions in an earlier era, and now we have all kinds of variants of those churches and religious schools and religious businesses and religious nonprofits, and then on the other hand, lots of regulations over all those entities. So you're right that there's an increased clash here. One of my concerns is that I think the lawyers understand the effects of Smith and a diminished free exercise doctrine, but it's not clear to me that sort of the person on the street who is running the nonprofit or the religious school or any of these organizations fully grasp that. So whenever we have a threat or a challenge to a religious institution, usually what I see in press releases and in conversation is, well, we've got the fundamental protection of religion in the First Amendment, and that's true as a historical or descriptive matter. It's less true as a doctrinal matter today.
Yeah, I mean, I've had Stephen Smith on from the University of San Diego discussing his recent book on religious freedom, and the movement in the academy he describes is to even dispute the very idea of religious freedom, even though it is in the text. But the idea, you would cabin it to a freedom of worship, thanks, and that would be pretty much it. Yeah,
that's certainly a move out there, and not just in the academy.
It's not an extreme position anymore. I mean, it's becoming very mainstream.
It is more mainstream, and it's reinforced in some of the doctrine, right? Not all of the doctrine. So a case like Hosanna Tabor cuts somewhat in the other direction, but there are reasons that these arguments are getting off the ground.
Yeah. What do you think, though, in this, thinking about your book, Confident Pluralism? So I take it that would be more an aspiration of yours, as opposed to the weak pluralism. We would think about causes of a weak pluralism, or a more monolithic society that we seem to be moving in, particularly on certain cultural questions. Just think of, and I'm interested to get your take here because you're actively teaching students, just sort of a nominalistic framework or a nominalistic epistemology that's just writ large in our culture. That is to say, language struggles to define reality, to define our experiences, to give us any real access or realistic understanding of the world. What we do have, though, are words as weapons that secure identities, make the society that which we want it to be. So we start to see everything is constructed through words rather than a correspondence with reality through using words to understand reality and understand ourselves. They become, in effect, almost like weapons that we use.
Yeah, or maybe I think, put the same point differently, the way I think of this is in a Macintyrian sense that words find meaning in argumentative practices that evolve over time. And so a concept like justice requires a broader practice and really a teleology, and absent those kinds of constraints and frameworks, we're just left throwing out words that sound rhetorically pleasing but have either no content or an ever malleable content. And so we use these words as trumps, and we use them to end conversations, and there's not a lot of thought always into what they actually mean.
So I'm curious, how do you see universities in all of this? Greg Lukianoff has argued that a unique weakness of the ruling class in America is precisely that they come from backgrounds that are so monolithic where they are never actually challenged on anything they believe, either in elite prep schools or in elite universities or in their professions. And as such, start to see arguments that disagree with them as, irrational, hateful, bigoted, etc. And this is a failure of the university itself, he argues, in many respects. This is the one place in your life where you are freed up from competitive market pressure, and you should be allowed to just study and investigate, make arguments along with the learning you receive from your professors. But that doesn't happen in many respects, he argues, and in fact, it's sort of actively discouraged. Do you see truth in that argument? Do you see universities failing in a role of contributing to the pluralism you describe?
I do think there's a unique challenge in higher education today, and part of it is from the university side of things, and I think a growing part of it is from the student side of things. So when we think about in the last year or two, some of the student protests on campus, some of them I think very well founded and pointing toward very important challenges and deficiencies in the university, but others really taking kind of a conversation ending approach to discourse, and so you have and now you have kind of progressive students and progressive faculty at odds with each other, and so it's no longer just kind of an ideologically situated argument, but it's all over the place, and the effect is to shut down conversation, the effect is to end conversation, and that doesn't seem to be at all what the university ought to be about. I think there's a related point too, which is that especially in elite education, there is a sense in which people just have fewer and fewer
disagreements.
Disagreements, but also just socially fewer interactions with people who are different than them, on, say, the religious context. And so this is sort of an early hypothesis, but my thought is that some of the elite lawyering we see against religious institutions that describe religion and assume it's just kind of an internal thing that you do within the four corners of each church, but you don't take outside of those walls. That seems to be driven from an understanding of religion that derives from a lack of experience with actual religious people, right? So when the Obama administration, in its initial regulation around the contraception coverage under the Affordable Care Act, limits the exemption to religious organizations that serve only their own, that's just a deficient understanding of religious practice in this country. Or when Iowa, just a couple of months ago, says that churches that open their worship services to the public might be subject to certain laws and regulations. Again, that's fundamentally misunderstanding what most churches do in their worship services. And this, I think, has to be tied to just a lack of awareness of actual religious people and practices.
Thinking about the point you just made, I thought that probably explains, or best explains, the position that the Obama Department of Justice took in a case you write about at length in your book, Hosanna Tabor. This was a case, correct me if I get the facts wrong, Joan, a church, a Lutheran church, conservative church in the Missouri Synod denomination, had released a minister from employment. It was question of was she a minister, I think, was at issue. But she was, I think, technically a minister as they defined it. and they were sued, under various federal civil rights laws. And the Obama administration took the position that they should receive no protection under what's called the ministerial protection doctrine. I think that's what that's called. They should receive no protection under it, and in effect, the only protections they get would be freedom of association precedent. So in effect, which that's pretty weak, as you note in the book, in effect, you could have the federal government picking and choosing your ministers. If the Obama administration got its way, of course, they lost 9-0 at the Supreme Court in that case. And it seemed to me that you can imagine the arguments internally in the DOJ for this position, and that no one raised a problem with that argument, or at least tried to find ways of limiting it. It was just out there, full bore, led me to think that there must be an incredible culture of insularity amongst lawyers at an elite level, center-left administration, all of that, Yeah,
I think there's a lot of speculation about sort of the litigation strategy of the administration and Hosanna Tabor. The one factual correction I'll make to your description was that the church employee was actually a teacher at a church-run school.
But she was called, right? She thought she was a called minister, or they listed her as that, right?
Yeah, sure, illegally. And actually, there were reasons that she herself claimed to be a minister. So the factual label of a minister worked here. But I think it does matter that we're talking about a religious school and not the church per se, which then expands the question of what kind of religious institution qualifies for this protection. Is it just the church? Is it the church-run school? Is it the nonprofit? Is it, these kinds of questions, which are very much in play right now. But I do wonder, to your point, the extent to which the administration lawyers wanted to acknowledge a religious distinctiveness or a constitutional distinctiveness to the church. There was doctrine, existing Supreme Court case law suggesting the churches were treated differently. The administration did not want to go down that path, and as you mentioned, they raised instead the expressive association protections, which I think one reason that they lost so handily here is that doctrine itself is quite unstable, and there's not a good sense that doctrine would have been strong enough to protect the church or other similarly situated religious institutions in the long run.
Oh, and the further duplicity would be that many of those same lawyers, we can assure, would have been arguing against, the most recent case there, Boy Scouts versus Dale, which the Boy Scouts famously received protection to define who will be their ministers, even excluding those of homosexual orientation. And even under the New Jersey Public Accommodations Law, they were given an exception there by the court. But of course, most of those lawyers, I think, in the Obama administration probably took a different position in that case, and probably even as things were going on, would be totally comfortable arguing for the overturning of that precedent as well, even as they relied on it in Hosanna Tabor.
Yeah, that might be right. There was not a lot of support for the Boy Scouts decision from folks on the left of the academy and the bar.
Yeah. So we think about freedom of association now. Of course, it's interesting when we talk about Hosanna Tabor and the ripple effects of that decision, balanced against a case you just mentioned, or we've been talking about Employment Division versus Smith, and how does an institution situate itself within those two kind of opposing frameworks, or the opportunities that they invite. This is all sort of leading to some sort of resolution, or pointing to some sort of coming resolution that will be, definitive in our law, and thinking about freedom of association and also religious freedom.
I think it's a live question. I read Hosanna Tabor as having quite a bit of tension with the Smith decision. So the holding of Smith is that if the government has a neutral law of general applicability, then a free exercise claim does not get any special scrutiny or protection from a court in reviewing that law. The challenge here is that the anti-discrimination employment law at issue in Hosanna Tabor was a neutral law of general applicability, and so the court had to figure out how does it distinguish this particular law from the general holding it had in Smith. And I think there's a real tension there, and so there were efforts in the opinion to say, well, the facts of Smith involved something that were not quite like an internal church-like practice, even though it involved a religious ceremony, and the court wants to say Hosanna Tabor is different. It's not clear to me that that distinction holds. And we are going to see, I think, at some point, a resolution of the clash between Smith and Hosanna Tabor. It's not clear to me how it comes out. And again, this is another example where complicating the landscape is just a vast array of religious institutions that are out there. So we're not in sort of the day in and day out legal practice. We're not just talking about the church with the steeple, but we're talking about the campus religious group and the soup kitchen and the international ministry and all of these kinds of entities and the extent to which they would qualify for these same protections.
Yeah, we've already seen, this happened locally here. In fact, it's the suburb I live in where a sexual orientation, gender identity statute was passed, and it even was applied to churches in their business functions, whatever that means. No definitions were given. I guess that's kind of the point. You could see a vast array of things fitting under that, even though, as we've been discussing, a church would understand everything it's doing as falling under a religious mission, even up to, including running a daycare or, whom it hired to do certain things for it. But that seems to be that's part of this.
Yeah, I think that all comes into play. And then a related question is, what's the scope of the protection that the ministerial exception extends and offers? And so, for example, a church now has the ability to make its own hiring and firing decisions, which have a pretty strong protection. But there's a separate question, for example, as to whether the government can choose to withhold money from that church in the form of a tax deduction or tax exemption or some other form of money if the church chooses a policy that's outside of governmental norms. And it's not clear to me whether Hosanna Tabor becomes a protection against those kinds of decisions as well.
Yeah. I guess one problem, thinking about your book and the confident pluralism, it's just a conceptual problem, I wonder, within liberal democracy itself, in that these associations, I think, it's almost as if we have to say they have a status on par with the individual in our law. If we tend to think of two entities, the state and the individual, but what actually we all do things in groups, and you make this point in the book in various ways, from motorcycle clubs to churches to various forms of civic association. We all do these things in groups, and yet these have a more tenuous hold right now, and you describe that at length. So, but I guess our problem is just the sense in which we don't see the need to make that a part of our rights and liberties right now. And as such, it tends to be everything is it's assumed under the more strident individualism that has started to emerge, in the last decade or 2 decades. In particular, it seems gay rights has really changed a lot of our thinking as well here.
Yeah, I wonder if it's a broader cultural and social set of changes that are responsible for the situation you just described. And part of it, I think, is just a growing inability to imagine or see the value of civil society more broadly, and this idea of mediating institutions, this Tocquevillian sense of what these groups do. A part of that is we just have such a broader range of groups today. So we not only have the motorcycle club and the book club or the church, but we also have the Boeing Company and massive membership list organizations and national unions and all kinds of pretty powerful and wealthy non-state institutions as well. And so what do we do with those, and what's their relationship to this, more idyllic Tocquevillian association? But those are really important questions, and I do think that in the law and also the cultural discussion today, the emphasis on the need and function and role of those institutions seems to be diminished. I think Yuval Levin's book, The Fractured Republic, is another book that really points to the urgent need to return to the significance of those kinds of groups.
Yeah, no, I wanted to ask you because I just interviewed Yuval Levin on The Fractured Republic, and it came to mind as I was reading your book, because what Levin argues is deconsolidated republic, a decentralized republic over the course of the last 50 years. But that all sort of, I think, feeds into, maybe a question we started with, which is, if we disagree about so much, what is there really to unify around? Levin, Yuval is pretty short on citizenship or that core component. He doesn't even really try to build a case for some sort of constitutional consensus, which I think you're referring to as a modest unity. And I wonder, I'm not sure why he's silent there, but I've wondered if is it just impossible now? But if that's true, then we're really in a bad way.
Well, right. I mean,
we're a cacophony of tribes, voices, and groups, and it often sounds that way.
It does seem that way. It's getting more difficult, but it does point to the, I think, value of some sort of ritual or ceremony or something that reminds us of being the people. And I sometimes worry about that kind of almost indoctrination, because it can certainly go too far. But there is a sense in which we unify when we see ourselves as a collective people. And oftentimes this happens with threats externally, or some kind of national pride moment that can take shape. The U.S. team wins the gold medal in the '80 Olympics or something like that, right? But we need more of those moments to remind us that there's a broader us there, even if it's a thin one. And I worry especially with how so many of us now experience the world and our neighbors and the issues of the day through social media, whether we've reached a point where there's no longer even the possibility of experiencing that. So even the best situations that might unify us are immediately translated and narrated in two very different ways.
Yeah, it's interesting. This makes it all the more important, the case you make for freedom of association. I like what you do in the book. You appeal back, so you think about, a lot of people maybe don't know about this, Vanderbilt University required Christian student groups to accept an all-comers policy, and required every group on campus, with the exception of fraternities and sororities, which is interesting, to accept an all-comers policy. So theoretically, a Democrat could become the president of the College Republican Club, and a Baptist could petition to be a president of the Jewish Student Union, which just sounds so strange when you think about it. And in response, Jonathan Rauch, I thought, who was gay, who made a lot of arguments for same-sex marriage, starting 20 years ago, which have now prevailed. And he argued that during a time in America, and you pick up on this argument in your book, when gay rights was not so favorably held, it was incredibly significant to have these associations for all sorts of reasons. And Jonathan Rauch just said, and for that reason, now we should allow expressly disfavored groups to have their same associations for that same purpose of purposes of what it unlocks for them socially, business contacts, political organization, etc. All sorts of good things can happen there. So there's a relational of value in these groups, and and as Alexis de Tocqueville talks about, right, this sort of unlocks our selfishness, or puts it down, and for a moment we think beyond ourselves and just think about the other people that we're with, and how good that is in a democracy, with all of the various individualistic effects that a democracy can produce. Tocqueville argues. You pick up on all those arguments in the book. It seems to me that's the public case that has to be made.
Yeah, I think that's right, and it's a broader, almost common sense point too, that the appeal that we as human beings and neighbors and citizens are often strengthened by being in like-minded groups and spaces where we get to, on our own terms, decide what's up for discussion and who the relationships are and these sorts of things. And we experience this, whether you're religious or not, you experience this in your day-to-day life, and you recognize that there are groups where you default to try out new ideas, or to form friendships, or to take risks. And that's, I think, just how we are as human beings. And the Vanderbilt situation seems particularly disingenuous to me, because the exemptions that they cover include not just fraternities and sororities, but also glee clubs and honor societies and all kinds of things where, again, the common sense point is of course you make distinctions for the glee club because you want people who can
Sing.
carry a tune together to be able to come together. And, I was not part of a fraternity, but I can understand why in some settings you might want only men or only women and these sorts of things. So the idea, the intuitive idea, I think, is there, but it's dismissed in some of these policies.
Yeah, no, I mean, people have made the same point with regard to yet another Dear Colleague letter from the Obama administration or for the Office for Civil Rights with regard to the transgender bathrooms, but yeah, expressly allowing single-sex sports teams. It doesn't all apply to those. This ruling, which in a way also just suggests something unalterable or at least good about allowing certain types of discriminatory practices to occur.
Yeah, the transgender questions are really fascinating right now, and I think there is a bit of instability in the law for the reason you mentioned, which is that the outcomes are fairly binary, right? You either have single-gender teams or you don't, or bathrooms or something like that, and the consequences of the logic I think are still playing out. And so we're going to see, I don't know what the time frame will be, 5, 10, 15 years, but at some point you're either going to have the NBA and the WNBA or you won't, right? And there are going to be consequences for that decision one way or the other, but the internal logic of some transgender rights arguments forces that question.
Yeah, I mean, and also there's just sort of conceptually, I mean, just thinking about how many genders are there. I don't see a limiting principle. I mean, I tend to think, I'm just trying to be logical here, there are as many genders as there are people who can, conceive of one. And the question then, how does the law deal with such a Cartesianism on steroids principle? I don't know. I don't know how you deal with that other than with incredibly large bureaucracies trying to manage all of the various gender identities and how they're going to interact publicly.
Yeah, I do. I mean, there are going to be some really complicated questions. I think, though, in the other direction, it also does not make sense to me that there would be conservative legislatures right now, like in the state of North Carolina, that are forcing this issue in the other direction and are making policy judgments that require binary distinctions in the other direction. So, for example, given the fact of transgender people in society, it doesn't make sense to me that you would require by law a transgender woman post-operative to go to the men's bathroom. Right? I think that just
my understanding is that North Carolina doesn't force that on post-operative. It expressly allows it, but also opens it up. Private sector bathrooms are able to negotiate whatever arrangement they want. This is, it applies to public bathrooms under however that's defined, public law in North Carolina. It was the Charlotte law that imposed it on the private sector unilaterally.
Yeah, the Charlotte law went first, and I mean, you might be right on the specifics, but I think the policy outcome here is that to the extent that there's any kind of forcing function here, you're going to have situations that might be less than ideal here. And I think that it's just not clear to me that we have the sociological...
Well, it's the arms race. It's the arms race. Is the federal government going to act, or how are the states going to react? Is the judiciary going to intervene or not intervene? It's because I think what you would point to in your book is this should be handled through local solutions. People who contact each other the most day by day, and daily contact would be the best place for this to be resolved. But of course, this smacks up against where I think we started, which is rights talk. And I have this trump now, and everyone must recognize it.
Right. Yeah. And then the other sort of complicating factor into some of the constitutional discussions now is the recent introduction. Well, the idea is not entirely recent, but the ratcheting up of this idea of a dignitary harm. And so the issue here is, if you do something to offend me that is an affront to my dignity, then that's a constitutionally cognizable harm that I can use to limit your expression or your rights. And I think that's a very problematic concept as well, because the experience of a dignitary harm is just inherently subjective, right? Yeah. And it's going to be very difficult to put into law what the contours are. And it's one of the reasons I think that our First Amendment free speech law has always gone out of the way to protect these kinds of expressions that cause dignitary harms. And so the fact that I might say something that deeply offends or causes emotional harm to someone else does not impinge upon my constitutional right to say that.
Yeah, I mean, but once we go the way of therapeutic, a therapeutic regime of law, I suppose free speech will begin to be diminished. That'll be pulled back more and more, it seems to me.
Yeah, I mean, it's certainly the consequence that some people are now arguing for.
Yeah, I mean, it's again the limiting principle. Interesting here too that you mentioned briefly the Iowa situation where the Iowa civil rights schnooger-dooger bureaucracy now on the lookout for sermons that I suppose would be offensive or to certain protected minorities. I'm not sure exactly what they're getting at there. I guess I was sort of thinking, well, one, the chilling effect of, this is something just, I think it would strike most Americans as deeply disturbing that sermons are being watched by the government, but yet, that somehow they're actionable to begin with. I don't know.
Yeah, I didn't see that part of the Iowa law, so I don't know enough to comment on it. But what struck me about the part I did see was that the state agency wanted to apply some of its reach, and it wanted to make a distinction between churches that just had the worship service internal versus churches that opened the worship service to the public. And what that seemed to miss to me was the fact that many
do we know of any church that only allows those who are members? A church. I won't speak to other religions. I can't even think of any that would say no only.
Right. No, it runs contrary to I think what most people experience church to be. Right. That you would.
Yeah.
Especially evangelistically oriented churches, which would say the whole purpose is to open the doors to.
Yeah, you think about. I see these large evangelical churches meeting in movie theaters where I'm at, or they meet in cafeteria. It's interesting, and the whole purpose I think is to be open to as many people as possible.
Right.
What do you think about the second part of your book, Virtues of the Tolerant Regime? We haven't discussed that much. Talk about what you're getting at there.
Yeah. So the idea here is that we have to have these civic aspirations and this sense of holding each other to a greater sense of how we interact with one another. And so I talk about the aspirations of tolerance, humility, and patience, and that we can and we must engage in these more with one another, especially across difference. And so even though, here's a good example, it turns out that, at least today, our free speech law gives us the ability in the breathing room to say a whole lot of things, and it's in public context. It's very difficult to constrain speech short of some well-defined limits like imminent threats of danger. But that doesn't mean necessarily that we should just use this right. This goes to your point about the responsibility that comes with rights.
Yeah.
And that because we have the ability to say whatever we want, it ought to make us think harder about how we say things to one another, especially to people who have different views, to people that we're arguing with. And so a lot of what I'm getting to here is our modes of discourse, the ways in which we actually shut down conversations instead of engaging with them. And here's where, in the recent news, we just see this over and over again, the inability on social media or elsewhere actually to engage across difference and the instinct to either call people names or shut it down or tweet something and stop, and it's becoming increasingly a problem in our day-to-day discourse.
Yeah, I guess so. John, I apologize. I did say the word virtue in that question. I apologize. Thinking about these sorts of good practices of the tolerant regime, I suppose something that we've been discussing is. Or we've been talking about it, is this idea though of power within America and who has the power, and I mean just sort of like soft opinion making power, and also it also does hard real legal power as well here. It seems to me though. There's just a clear imbalance on a range of questions, but questions that we talk about gender identity, sexual liberation question. Now it's very difficult, I think, to still make an argument against same-sex marriage. I think that's become even more problematic. And so there's my point being, why would the other side give here? Or I say the other side, but those who have that power in major institutions throughout the country. It seems to me they have no reason to bargain at this point. It's just, first down and 10, and we're going to keep shoving this down your face. You mentioned this in the book. Solicitor General Bob Varelli, during oral arguments in Obergefell, strongly hinted that the Bob Jones rule, where Bob Jones College lost its tax exemption for bans on interracial dating and relationships, that same precedent would be applied to religious colleges who continue to object in various ways to homosexuality. So right away, it seems that this continues to get much worse, and it doesn't seem just on the basis of politics and relative questions of who can do what to whom that they have any reason to negotiate.
So I guess two things on the power imbalance. One, it's complicated, and it's complicated by locality and by region and these sorts of things. So on some issues, there's a power balance in one direction, but in other issues, take some small towns in the South, for example, where even though the Supreme Court ruled on school prayer 50 years ago, there's still school prayer in public schools going on. If you're a religious minority in a small town in the South or an atheist, you might experience a whole lot of hostility and power in the other direction. If you're a person of color in a minority community in a big city where policies are set by people who aren't of color, there are power imbalances there. So the power question, you're right to point to it, but it's really all around us, and it cuts in lots of different directions. And in each case, the question is, do those who hold power, are they willing to acquiesce in some aspect of that power for the sake of pluralism, for the sake of kind of tolerance and coexistence? And the human tendency here is often no, right? If you have power, you want to keep it. And so what are the practical arguments to make in that case? Well, one of them is the balance of power changes, and it can change quickly. The current happenings in the university setting in some corners are showing this, where suddenly, a rise in a kind of student power against some progressive faculty who previously
save me from my students, one professor said.
Right. So this is quite right. This is quite new, quite different, quite rapid, and so suddenly, there's a power imbalance that happens quickly, right, and that shifts. And so that's one reason to be reticent for those who are in power. But the other thing, I think, and this is really for me, the point in writing the book, that I think there are those on left and on right who have no interest in pluralism or mutual coexistence. For them, this is just a power grab, and if they get the power, they're going to do everything to keep it. But my hope, at least, is that there is a big enough section of the country that recognizes we do have a lot of differences. These are dynamic questions. They're dynamic differences. The power holders shift over time, and that it's better to figure out a way to live in coexistence rather than to just use the power plays. And I don't know. That's kind of a question to be determined if that's right or not.
Yeah, no. I suppose I see things a little bit. Well, I say a little bit more darker. I think than you would. You make a good point there in terms of what some people might experience. Although overall, it seems clear to me that there's a dominance of elite opinion that is national in scope. It's interesting that with the transgender initiatives or objections to religious freedom seem to be all in the South, which would suggest to me, yes, the South is a holdout from postmodernity, but we'll see for how long. Because of the power of the federal government, in particular the power of the administrative state, working and sort of redefining law, as it were. John, thank you so much for your time. We've been talking with John Inazu about his book, Confident Pluralism, with Chicago Press. Thank you so much for your time.
Richard, thanks so much for having me.
This is your host, Richard Greinch, and you have been listening to a podcast that can be found at libertylawsite.org, where you can subscribe, comment, and find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org.